patent sucks because you haven't connected the benefits of your invention to specific structural features. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. One of the things I work really hard at with clients is trying to get them to engage in thought exercises where they really drill down on why their invention is as good as they think it is. Because they often come to me and they say, it does this and it does that, and they describe that in very broad functional terms that are often too indefinite to support a patent claim and too broad without supporting details to make a patent enabled, which it has to be. So the key is, when you're listing these things that you think are great about your invention, to connect them to specific structural features of the product. If it's flexible, why is it flexible? Is it flexible because of the shape? Is it flexible because of the shape and the dimensions? Is it flexible because of the shape and the dimensions and the material? Are there different materials you tried that had different degrees of flexibility? Were there different ratios of dimensions you tried that had different degrees of flexibility? Now, all of you people who are new at this bristle at these questions because you're afraid that they're going to limit your patent. And that's not why I'm asking you about them. And if you don't have them, there's two big risks you run. The first is that you won't have an invention that's enabled. And if that happens, either you won't get the patent at all, or if you do, it'll get knocked out in litigation for lack of enablement, which is a defense. But the second and more common problem is that most inventors significantly overestimate the breadth of the patent they think they're entitled to. And so they come in thinking they're going to be entitled to really broad protection, which is very rarely the case. And if they're not entitled to that very broad protection and they haven't drilled down to further details, they won't have anything left to limit their claims to, so they can distinguish their claims from the prior art. I mean, I can't tell you how many times the patent my clients get is based on some feature that we teased out after doing some work on it to figure out, why is it you picked this material? Why is it you made it that shape? What are the variations that would have worked? What are the variations you're sure wouldn't have worked? And we start to figure out what exactly is it, the core feature that gets you these benefits that you're talking about when you're talking about it almost from a marketing perspective. It's faster, it's thinner, it's more shiny, whatever. What are the structural features that get you there? Now, sometimes it's pretty hard. Like sometimes when a client's doing something and they're buying like off-the-shelf polymeric materials, that's tough for them because they really don't know what they're buying, a lot of them. And for something like that, you have to gain familiarity with the standard tests that are used. Things like Shore hardness and percent elongation and tensile strength and shear strength and a whole bunch of other measures that ultimately determine why a particular material is the best for a particular application. Or I think about medical devices. If somebody tells me that it's really good for this particular surgical procedure, well, it's like, why? What part of the body is it going into? What are the important issues when you're going into that part of the body? What is it you did to tailor it so it would do that? And if you develop that stuff, you're going to get a much stronger patent application and ultimately a much stronger patent. And like I said, a lot of my clients, they end up getting a patent, but it's not necessarily the one that was as broad as they wanted because there was too much prior art, or the prior art was just too good. But they can still get a good patent if they've thought about some of these things. And I can assure you that none of us are trying to limit your invention. We just want to be able to later if we have to, because, if the prior art's too close, you got to limit the claims. You have no other choice if you want a patent. It's just the way it works. You don't get to just ask for the scope that you want. You're not writing on a blank slate. You're writing on a slate against the prior art. And whatever you put in those claims has got to be novel and not obvious relative to the prior art. Okay, so anyway, I hope that helps to keep you out of trouble, and I hope to see you here soon.